I'd like to thank the Attorney General for those kind words and generous introduction. I do remember very well the Open Hydro case, and that's one of those situations in which, as they say, you get experience is what you get when you don't get what you want, and I had a lot of experience in terms of how to run a case by being against Rossa in that one. The remarks that he was making with regards to Irene's paper are very relevant to the issues that I want to discuss this evening. So we touched on the issue of the private enforcement in relation to directors' duties, and also issues pertaining to the question of costs and the difficulties in an insolvency situation in which there aren't sufficient funds available in the company to defray those costs. Those are issues that arise in a very interesting and novel context now, because my topic for this afternoon is inspections under the Companies Act. And while this is to some extent a kind of dry and dusty topic, having been around for about 100 years or thereabouts, there have been some very interesting new developments. That was the general view, that this was a sort of a trick that was being perpetrated on people who would do business with companies. And that level of mistrust has even from time to time affected members of the judiciary. And funnily enough, one of the privileges perhaps of preparing a paper like this is that one gets to go back and look at some things that one hasn't looked at for a while. Now, when the case came before the House of Lords, the unfortunate Mr. Sullivan, who's now a pauper, according to the report, obtained a very different result. So Lord Halsbury, the Lord Chancellor, accused the trial judge, Mr. Justice Vaughan Williams, of a very singular contradiction, because he said either the company was a legal entity or it wasn't. If it was, the business belonged to it and not to Mr. Sullivan, and if it wasn't, there was no person or thing who could be his agent, potentially to open a new front of corporate lawfare for disappointed creditors who may have reason to suspect foul play either by the company or by company management. And there is, in fact, another case currently pending before the High Court in which a similar application has been made, which has not yet been decided. It was the Companies Act of 1990 that really revolutionised this jurisdiction, and it transferred the power from the Minister to the High Court, and the application could now be made by a single director or creditor of the company. It also introduced in Section 22 a very important provision which said that the inspector's report was admissible in civil proceedings, not merely as evidence of the opinion of the inspectors, but also of the facts set out therein without further proof unless the contrary is proved. It's a fact-finding purpose. The purpose is to find facts that are not known. And a number of things follow from that. Perhaps the most elementary and most important of them is that if the facts are already known, it is not necessary to appoint company law inspectors. And the courts have repeatedly endorsed that. So it is a function of fact-finding and reporting. But as I say, it's a very interesting development in what is a very interesting overall jurisdiction. It remains to be seen what will come of it, but we're watching with interest. And as I say, there is at least one other application currently before the courts in which this is going to be tried. So thank you all for your attention.